Okay, Norman SVOBODA versus BAYER Corporation. And there is a cross appeal, so if both sides, if you want to reserve time again, I'll try to let you know when you get to that remaining time. Would you like to reserve any time?
I can't proceed with the prior argument. If I left with 6:32 left, I had 6:32 to remote.
Exactly. You'll keep track of yourself?
Yes. Okay.
And if you'd like to reserve some time for rebuttal on the limited issue raised in your cross appeal, then you're welcome to do that as well. So, thank you very much. Okay.
May it please the Court. Good morning. My name is Tim O'Brien. I represent Norman SVOBODA. The case below concerned a man who had a stroke at the age of 52 years old, massive hemorrhagic stroke. This was a drug that he had taken called Alka-Seltzer Plus. At that point in time, in 1998, had an ingredient called phenylpropanolamine. In November 2000, the FDA required that the ingredient be pulled off store shelves because it was causing people to have strokes. But that's not when the FDA first knew. It's not when BAYER first knew. In fact, the FDA was considering as far back as 1985, as the record demonstrates, banning PPA. And so the issues before the court are several. The trial ended in a defense verdict. The court below erred, number one, by failing to grant the punitive damages proffer, which was filed.
I'll just ask you with respect to the punitive damages question.
Yes, sir.
If you prevail on some other part of the appeal, excuse me, that would justify a new trial, then that issue requires consideration. On the other hand, would you agree that if you don't prevail, that issue kind of goes out the door?
I agree. It's derivative, Your Honor.
Okay.
The second appeal would be, the second appellate point would be the court improperly excluded on defendant's motion in limine evidence that BAYER had destroyed its safety committee minutes, where they had discussed PPA during the tempest that was going on in the early 1990s when the FDA was again considering, do we ban this drug?
Well, was there actual evidence that they discussed PPA at the meetings where the minutes were destroyed?
Yes, under Dr. Wenger. Dr. Wenger said he was familiar with the safety committee. He was familiar with the fact of its existence. He was familiar with what it was charged to do. And when he was asked, what would it have looked at PPA? He goes, yes, that would be the responsible thing to do. Now, whether
he never attended one of those meetings, correct?
He was a supervisor.
He never attended one of those meetings, correct?
No, that's correct. But
and he never discussed with someone who did attend what was actually discussed at the meeting, as far as the record reflects, correct? I mean,
as far as the record reflects.
So all we have is his speculation that this is something that should have been discussed. He believes it would have been discussed, but he has no personal knowledge as to whether it was or was not discussed, correct?
Respectfully, Your Honor, I take a slight different tact in it. It was within his scope of employment to know what they were talking about. And so he was a supervisor.
If he never saw the minutes, never attended a meeting, and never talked with anybody who attended a meeting, how did he fulfill his responsibility of finding out what happened in the meeting in order to give that testimony from any personal knowledge?
As far as the record reflects, what he said, he was the supervisor of clinical research and affairs. He knew of this committee because it was within his scope of employment to know of this committee. The issue about whether they actually talked about it or not, it's relevant because if they did not talk about it, that's relevant. Because he said it would be responsible of them to do that. I am a BAYER employee. The responsible thing for this committee to do would be to talk about PPA. So if they didn't talk about PPA in these safety committee minutes, when they are charged with the responsibility of looking at the safety of BAYER's drugs, then that's admissible. That's relevant. The fact that they did not talk about it, we didn't get to talk about it at all at trial, that this safety committee existed. That was entirely excluded. So whether they...
But what inference is drawn, even if the safety committee had talked about it, and there's no evidence that they did, maybe they should have, but let's assume that they did talk about it or they didn't talk about it. At the end of the day, this case really still comes down to a causation issue. Did the ingestion of this drug, was it the legal cause of Mr. SVOBODA's stroke? And I'm not sure how their discussion, whether they talked about it or didn't talk about it, didn't cause this drug to cause his stroke. It either did or it didn't. And it seems to me that the jury heard an abundance of testimony with all sorts of, experts on that relationship.
I'm sorry, my time is not right. Well, when a party admits, Bayer contested that it general causation, that it causes stroke in anybody. And so if you have an admission,
They said it could cause a stroke. I'm sorry, I didn't hear what you're stating.
Bayer contested, said, we don't think PPA has caused one stroke nationwide. And so when you have a safety committee whose duties include looking at this issue, if there is an admission by the charged safety committee that it is causing strokes, then that goes to general causation because you have an admission of a party opponent. So that's one issue. The second issue would be with respect to the issue of negligence. Was Bayer negligent? Okay, then you get to the issue of causation. And did that negligence then cause it? So we have to get to that first bridge first, keeping in mind that the way the verdict form was read, it was combined. Was there negligence on the part of Bayer which caused it? Was there a failure to warn which caused this? Was there this? Was there that? And so all of the negligence and causation questions to the jury were tied together. And when you have that first element, was there a duty and was it breached?
We're talking about an abuse of discretion standard, correct?
Yes, on the exclusion of the evidence, correct.
Based on the evidence that you presented as to what might have been discussed, you now have a theory that either the minutes were relevant because they didn't discuss the drug and they should have, or they did discuss the drug and so it shows something. So under those circumstances, what inference do you think the jury was supposed to draw from testimony that there were minutes of a safety committee meeting or meetings that no longer exist? And why wouldn't that be confusing to the jury? I mean, I'm having a hard time finding why the judge abused his or her discretion in saying that it's just more confusing than probative.
Because what the court did was it weighed the facts. It did the jury's, all of this goes to...
What's the jury supposed to infer? Because the jury doesn't know whether they discussed it or not. If they did discuss it, you infer one thing. If they didn't, you infer something else, but we don't know. So, I mean, that...
Here's the fundamental veer that the course took was Dr. Vanderhaar testified live at trial as Bayer's corporate representative. He was the person who told Connie Kent in her corporate representative capacity as a corporate deponent about the destruction of these minutes that, yes, we destroyed them back in 1997. So because that evidence was excluded, I couldn't ask Dr. Vanderhaar about the intentionality, about what was reviewed, about what was looked at. I couldn't talk about it at all.
Well, let me ask you, with regard to the destruction of these documents, aren't you, to have probative value, aren't you really trying to get three inferences? One, first inference is that because they had a safety committee, they spoke about this drug. Two, that their discussion said this drug is potentially dangerous. And three, in 1997, they said we better destroy it because it could be used against us in an adverse fashion. I mean, aren't there really three inferences before it reaches a probative value?
I don't think all three have to be met. I think that the issue has to be was there evidence that there were documents created? Yes.
Well, if they discussed it and said, hey, this drug is great and there's no danger, how would that destruction create any probative value to the jury?
Because keep in mind what the fundamental purpose of the safety committee was. It was to review the safety issues pertinent to our product. And when you look at the record, when you got in 1991, the FDA saying, look, this drug had the highest number of adverse events in young people, serious adverse events in young people of any drug in the U.S. history. And at the same time, the safety committee is looking at the safety issues of all over-the-counter products, including presumably PPA. When you link that up and say, if this safety committee didn't look at it, then they're burying their head in the sand. And that is a breach of the duty they owe to the consumer, particularly in the over-the-counter context. There's no learned intermediary in an over-the-counter case. The consumer has to rely upon what is told him or her when he reads that box. And they're never warned of stroke. So at this point in time, when the FDA is advising the cognoscenti, those within the know of what's actually going on, that narrow group of people who actually read the Federal Register, including BAYER, that, look, this is the highest number of adverse event reports, and we've got a real problem with it. And the safety committee at that point in time is looking at it. The only inference that could be drawn was, if they did not look at it, then that was a breach of the duty owed to the consuming public, because they were charged by BAYER with the responsibility of looking at the safety of its products. So it imposes an impossible standard upon an attorney who is trying to introduce evidence of destroyed documents. Whenever you lay out the relevance, that it's relevant to talk about safety.
What's the relevance of the fact of the trial court's decision that the corporation was under no duty to retain the documents? I mean, there was no lawsuit pending, there was no threatened cause of action, there was nothing that would legally require them to retain the documents any longer than they did.
Bayer had been sued back in early 1990 and 1991 in the Maisel and Sondergaard cases. Bayer had been sued several times before 1997. At the point in time in 1996, as the administrative record reflects, as we honored the regulatory issues before the court, the Yale study was going on, this hemorrhagic stroke project was going on, and...
Are you suggesting that they did have a legal duty to retain these documents?
No, I'm sorry, I didn't address your question. If they did not have a legal duty to address it, then it's only an adverse inference. If they had the duty, then under Martino, it's when the presumptions arise. There's a difference, of course, between the rebuttable or irrebuttable presumption of negligent or intentional destruction versus no duty and simply an adverse inference that these documents were destroyed. From the standpoint of addressing the court's ruling in this case, she didn't get to that level of specificity. The ruling was based solely upon Dr. Wanger's testimony versus Ms. Kent's testimony, and she weighed the facts. I want to jump now. I see my time is running. I want to jump, if I may, with your Honor's permission, to the court's refusal to strike Dr. Frederick's testimony. Dr. Fredericks testified that it was her opinion that sex caused Mr. SVOBODA to have a stroke. She admitted, when I questioned her, I asked, you can't tell this jury under oath as a professional neurologist that it's been proven that sex causes aneurysms to rupture. And she answered, no, I can't. And what was important when you...
Wasn't her testimony really somewhat different than that? Wasn't her testimony simply based upon her clinical experience and sidewalk consultations with neurosurgeons or something, which has recently been addressed by the Supreme Court? But be that as it may, wasn't her testimony simply was that there appears to be a relationship between sexual intercourse and the rupture of aneurysms, not that having sex caused a stroke?
What she did was assumed a fact. She assumed that Mr. SVOBODA had a Valsalva maneuver. There was no evidence that everyone who has sex has a Valsalva maneuver. Valsalva is when it's a expulsion of the diaphragm. It's a very discrete biologic fact. And as we learned from Dr. Muldoon's testimony, this was a theory created by the attorneys, that the Valsalva maneuver...
Let me ask you that. This is the major concern that I have about this particular argument. That is that you're arguing that there was no scientific basis for this testimony.
Yes.
And yet, as I understand and reviewed the record, it appears that your own expert, without objection, was impeached with an authoritative text that apparently was recognized as authoritative in the field. I think it was Dr. Kaplan's text, which said that activities like sex and other activities that cause exertion, physical exertion, can lead to or cause aneurysms. So, I mean, it seems inconsistent that there's testimony, there's this impeachment testimony from an authoritative text, and yet you're arguing that there's no basis in science for this opinion, and that's the basis for your objection.
Well, first, number one, Dr. Muldoon said in his earlier deposition, no relationship. Number two, Dr. Fredericks said there's no scientific basis for it. Number three, the text actually says that this occurs during sex, not causally related to. There have been reports that this occurs during sex or defecation or what have you.
Well, counsel, let me ask you this.
Yes, sir.
You know, if I understand the theory here, the theory is not that the PPA caused Mr. SVOBODA to have an aneurysm. Apparently an aneurysm was just some sort of pre-existing physical condition that he had.
Yes,
I
sir.
mean, it doesn't really seem to be something that it seems to be a matter of common sense that if you have, I mean, if I go out in my yard and my garden hose has a big bulge in it because it's weakened, if I turn the water on very slowly and at low pressure, I've got far less of a chance of a blowout of a garden hose than if I blast away at it. And it seems to me to be a matter of common sense, if once one kind of understands what an aneurysm is, that any activity that would cause the blood pressure to go up, whether it's jogging, having sex, heavy lifting, any sort of exertion, I mean, it just seems like it's a matter of common sense. I mean, I don't know how you would go out and study that.
Well, the problem is Dr. Muldoon, their blood pressure testified exactly contrary. He said there is no blood pressure relationship between sex and stroke. So that issue was taken care of Dr. Muldoon and not by Dr. Fredericks. Dr. Fredericks, here's where the issue
was his testimony that there's no relationship between sex and stroke, or that there's no relationship between, that blood pressure does not increase during sexual activity?
That was his testimony. There's no, he's a blood pressure specialist. There's no relationship between sex, blood pressure, and stroke. What he then deferred to was on this Valsalva issue. That's where we got to come back to. In this Arkin case, the Supreme Court case of Arkin, let me, if I may, just indulge me for a moment. The basis, this is on a workers' comp case, which actually has a lesser standard where causation can be inferred, where if there's an inference of causation, you can sustain your level of proof. The Supreme Court writes, after they excluded an expert's testimony that a fall, which broke a hip and then 2 days later caused a heart attack, was not admissible. The basis for conclusion cannot be deduced or inferred from the conclusion itself. The opinion of the expert cannot constitute proof of the existence of the facts necessary to the support of the opinion. That is exactly what Dr. Fredericks did. She assumed that he had the Valsalva. She assumed that. She already admitted that there's no scientific basis for it, but if there was, then it goes through the fact of the Valsalva. And that gave an improper inference to the jury that, number one, he had a Valsalva when there was no evidence of that, and therefore that this ipsa dixit opinion is proving that he had Valsalva, because if he had a stroke due to sex, it was because he had the Valsalva, but there's no evidence that he had the Valsalva.
But to come back to Judge Lawson's question, apparently your expert acknowledged that Dr. Kaplan's book stated, quote, aneurysms may rupture at any time, but especially when blood pressure or blood flow are increased. Rupture often occurs during strenuous activities such as weightlifting, exercise, sexual activity, et cetera, et cetera.
Right. All of these involve the Valsalva maneuver. When you squat, all of these supposedly, you have to prove it. You have to prove the facts. Say, well, look, 90% of the public has a Valsalva when they defecate or do whatever. You have to prove it up, and she didn't. All she said was, I assume he had that because that's how you have the stroke.
Let me ask you, did your expert testify that the only possible cause for this aneurysm breaking was the PPA?
He said the most likely cause was a PPA.
But did he say the only possible cause?
He said he did a differential diagnosis and he ruled out all of the possible causes. And so
he went beyond more likely. He went this is the only possible way.
This is a differential diagnosis. I've taken the most likely cause because of the other confounders. Keep in mind that most of the aneurysms, over 90% of aneurysms in the population never get larger than 10 millimeters. And it's only when it's after 10 millimeters, and all this evidence was presented, that it really presents a substantial risk of bursting. And even at that level, it's like 1 out of 1,000. And what Dr. Kiwak testified was, look, this was a 4 to 5 millimeter aneurysm. This was a non-popping aneurysm because it was so small. And so that's how he came back to this differential diagnosis of, well, we've excluded these other bases for it. We have to look at what PPA does to people.
But if there's other possible causes, and one being the authority, which your expert recognized, and then listing other possible causes, and what's wrong with a qualified physician knowledgeable in the area from giving an opinion as to other possible causes, even if she doesn't say this was the cause in this case?
Because she assumed the fact. She assumed the fact of the Valsalva. And she didn't, there was no evidence in the record. Her opinion created the fact that Valsalva occurred when there was no basis in the record for that. So with that, having been said, Your Honor, I'd like to preserve the rest of my time for rebuttal.
If it please the Court, Don Scott of the Colorado Bar for Bayer. I noticed the docket sheet listed Mrs. Litton as the person appearing for Bayer. I was chief trial counsel below, and I filed an appearance in this appeal. I tried the case below with Mrs. Lowry and another colleague. Beginning where Mr. O'Brien did on the issue of the safety committee and the document destruction, the plaintiff's position with Judge Alley was to let the jury decide if Bayer destroyed the documents on PPA safety and then get an adverse inference. What they forgot throughout the argument is that the trial court needed to make this determination as a preliminary question of admissibility under Rule 105, including the competency of the witnesses to testify that documents existed containing information about PPA safety. The court asked the right question in the hearing of August 31st, 2004, where this issue was heard and decided. The trial court asked, in discussing the plaintiff's claim that Dr. Wenger had testified that minutes would address PPA safety, she asked, if Wenger was not a member of the committee, how would he know? The answer by plaintiff's counsel was not to answer the question. Your Honor, it's a public policy issue. If the plaintiff is proven right, if the plaintiff has to prove what is in the documents that have been destroyed by a defendant corporation every time, it's almost impossible. That's at 3124 of the record, beginning at line 24. She asked the right question. How would this witness know? Because she had determined competency. And she did not get an answer to the question. She heard the straw man argument that would make it impossible for us because we don't know what's in the documents. And then in this appeal, Your Honor,
Does Bayer have an ongoing duty to assess the safety of products it puts out on the market?
it does do so and believes it has a duty to assess the safety.
So what inference, if any, can be drawn from, assuming that the safety committee is the venue where these sorts of discussions would take place, and it appears to be. If the committee did not, over the years that Alka-Seltzer Plus with PPA was marketed, if there was no discussion of the safety concerns, is there an inference to be drawn that Bayer didn't satisfy its ongoing obligation to ensure safety? And if there was a discussion and they concluded based upon the evidence that later proved to be erroneous based on the Yale study that the product was okay with PPA in it, isn't that also an inference? I mean, it seems to me that there is an argument to be made that if in all the years this was marketed with PPA in it, they never talked about it, they thought it was just dandy, despite the fact that there was, I think everybody would accept, a fair amount of rumbling, nothing definitive, but some rumbling out in the industry about PPA. If all the years go by that it's marketed and they never talk about it, what inference should a jury be entitled to draw from that failure to ensure the safety of the product?
The predicate of Your Honor's question, Bayer was conducting clinical trials and studies during this period that addressed efficacy and safety of the product. It was not done within this group. The plaintiff has called it a safety committee. Dr. Wenger called it a safety committee on which he was not a member and never attended. It was a group that included 3 members of Bayer and 2 outside consultants that was pulled together for a different reason, which was to address protocols for clinical trials. Now, those have safety implications, but it was not a standing safety committee.
Was there a committee, and I recognize that you're saying that this was more this committee in your mind was more to establish the ground rules for ongoing studies. So with whatever ground rules had been established, you said there were ongoing studies of the efficacy of this product.
And safety.
Right. Were those minutes preserved and ultimately disclosed to opposing parties in the litigation?
Yes, they were not minutes, but they were study results that were written up. It was not a committee.
Right, I understand.
But those results were not only preserved, Judge Ortfinger, they were presented in trial. These were studies comparing Alka-Seltzer Plus to other products that may or may not contain PPA that were or were not effervescent. And they never found a significant difference in blood pressure, either as an average or in terms of hyper-responders. They did not find any safety implications. So these were done. They were written up. They never found anything adverse, and they were produced and they were used in the trials of these cases. In the hearing on this issue, just to conclude on this subject, the trial judge asked the right question. How would this Dr. Wenger be competent to say what's in this stuff? And she did not get an answer. She had to make a decision whether to admit the evidence, and she left it open. If you come up with something else, tell me. And she was never shown competent evidence to suggest that there were any minutes, any documents that would have contained information, discussions about PPA safety from that particular group. That was not an abuse of discretion. On the issue of sexual intercourse and aneurysmal rupture, the plaintiff's expert, Dr. Kiewak, brought this subject up in his direct examination, where he testified at 941 of the record that there is nothing in the literature to suggest that sex is a risk factor. None of the studies show that it's a risk factor. There's no place where it's considered a risk factor. Line 17. In response to that statement by plaintiff's expert, they are both cross-examined, as Your Honors have pointed out, with Kaplan's textbook at 1009, 1010 of the record, where Dr. Kiewak conceded with the Kaplan textbook essentially what Dr. Fredericks then later testified during our case, which is the clinical observation, not causation, but the clinical observation that aneurysmal ruptures, as one form of stroke, aneurysmal ruptures occur during many different types of activities, but they're very often observed during strenuous activities like heavy exercise, sex, defecation. Now, Dr. Fredericks in particular, in her testimony at 1973 of the record, as Judge Ortfinger pointed out, it's very important to see what she actually said. She was never asked about causation of plaintiff SVOBODA's stroke. Rather, 973, line 24, what is the relationship between sexual intercourse and ruptured aneurysms? This is after she's testified in direct about the many different daily activities where it's observed to occur, even during sleep, aneurysmal rupture. And she answers, well, it's really more of a clinical thing, in the sense that there's no big studies. And she continues. And she continues and talks about the Yale study questionnaires, and that part draws an objection. But she said it's a clinical thing. It's something clinicians observe, which is the same thing Kaplan's text had said in the cross-examination of Kiewak. And she went on to explain the Valsalva maneuver and what it is. This was pure opinion.
I think counsel's concern, though, is that there was no predicate for her to opine that the Valsalva maneuver, which I admittedly had to look up to see what that was, that occurred here, or that occurs as a normal part. You know, I can't tell you I read every single page of the record. I don't remember if there was anything that says the Valsalva maneuver occurs as a natural part of sexual activity or doesn't. And so if there's no direct evidence, or at least even circumstantial evidence of that occurred, then upon what does she premise that opinion?
And she did not use those words, Judge. And perhaps that question should have been asked. There also was no objection made. There was a predicate missing as she gave that testimony. What she was doing was explaining in general why sexual intercourse is observed commonly in relation to aneurysmal ruptures. And she was not talking about causation in Mr. SVOBODA's case. It's very important to note what she did not say. She was not talking about what caused his stroke, and she did not imply it either, because she disclaimed that when she was asked on cross-examination by Mr. O'Brien whether or not that she was talking about causation, and she said that no, she was not, at page 2081 of the record. She was not talking about causation, but about a relationship that clinicians observed, because aneurysmal rupture was observed in relationship to all kinds of activities, and sex could not be excluded. Your question to me, Judge Orfinger, is if she had opined that sex caused his aneurysmal rupture, what predicate was there for that? She was not opining that it caused his rupture. She was saying it could not be excluded. And this is important in the context of the trial. The plaintiff brought up the issue of sex, and I want to tell you why. Here I'm saying that our expert was not opining that it was the cause, so why were we talking about it? In this trial, like all that I've done, there's a specific question and there's a more general question. Obviously, the specific question here was, did PPA in Alka-Seltzer Plus cause this gentleman's stroke? Okay? But that was tried against a more general dispute, where the plaintiff claimed that an aneurysmal rupture had to have a precipitating event, probably believing that has a natural appeal to a jury. It must have a precipitating event. Something immediately before had to happen to cause this. They said, yes, it had to have a precipitating event, a trigger, and we said no. Our position was, to our experts, that aneurysms have a natural progression. They develop, they expand, and the walls get thinner until they actually reach the thinness of tissue wrapping paper, in Dr. Postal's testimony. Tissue wrapping paper. They don't take anything to rupture. The plaintiff said there must be a trigger. And this was in the opening statement, Plaintiff's Counsel, page 275. Keewack will explain that, he said. When Keewack took the stand in direct, he went through a list. He said, must be a trigger, and he went through a list to rule out everything else and leave PPA left at the bottom as the only suspect. That was a trial approach they took. Rule out smoking, alcohol, oral contraceptives, hypertension, illicit drugs, rule them all out. And they're left with two things that did happen: sexual intercourse and a congenital defect in that A1 artery segment, which happened to be two of the big issues in the appeal. He wanted to cross those off also and leave PPA as the only thing at the bottom to put a circle around. And that's why Keewack denied that sex could have anything to do with this rupture, and denied that this guy had any congenital A1 defect. So he could leave PPA as by process of elimination. Well, that was just wrong. He went out on the limb to say nobody recognizes sex, no place, as related to aneurysmal rupture, and he was just wrong. We were responding to his statement, not contending that we could prove that caused Mr. SVOBODA's stroke. We have a right to respond to the plaintiff's expert when he makes a statement like that. Interestingly, as Dr. Frederick's testimony went in, was challenged here, there was no request for a Fry hearing. There was no objection based upon Fry. I noted there was an objection based upon her commenting on why something was in the HSP questionnaire. And there was no request for voir dire. It's interesting. The plaintiff is arguing that her pure opinion here is subject to Fry, and we could argue about that. I say it's not, clearly not, where it's based upon clinical experience. But they did not object, because the plaintiff apparently made a tactical decision that rather than objecting, they were going to cross-examine her about having no basis. They knew it from the deposition. He uses the deposition in the cross. They want to cross-examine her, not once, but over and over again, about what studies do or do not exist on sex and stroke, to drive home the point to the jury, not to the judge for purposes of a Frye objection, but to drive home to the jury that, in fact, it was pure opinion and shouldn't be relied upon. Well, they were entitled to do that, and they did. But in the process, they made no objection under Frye. They addressed nothing to the court until after she had left the stand. And in the meantime, drove it home to the jury over and over again. So by the time they asked Judge Atlee to strike references to sex, there were more of them in their cross-examination than there were in the direct. And in fact, she'd never testified that that caused the stroke in the first place. That is a straw man. She expressly disclaimed that. Although, and this was not an abuse of discretion, the judge recognized the jury had heard it all, the direct, the cross, Judge Frederick saying, I'm not testifying about causation, I'm saying there's an observed relationship, and the jury could decide that it was not abuse of discretion. One issue that Mr. O'Brien did not reach, but he has some time left, is on this sequestration issue on the angiograms. I'm going to be brief on this, but it ties directly into what I was saying about Keewack saying, I'm going to cross everything off this list. The way this came up is he's being examined on his direct, page 956 of the record, line 3. Did Mr. SVOBODA have a congenital defect of his A1 segment or congenital aplasia? No, he did not. So we can check this off as a risk factor. Yes. Now, the importance of this congenital defect. We are supposed to have these A1 segments, these arteries on each side. If there's a defect on one side, so it's either missing or it's there but there's no blood flowing on one side, the other one has to make up for it, more blood flow, and that increases pressure that contributes to the development of an aneurysm and the risk of rupture. That's why this missing segment was important. It's on the opposite side from the aneurysm where the flow had to be compensated. Keewack had to explain why, if there was no A1 segment on this angiogram X-ray, if he claims it was there and not defective, why couldn't we see it? And his answer was, aha, there's a blood clot. It's there. It's just fine. But PPA caused a blood clot that's blocking it off so we can't see it in this picture. Okay, blood clot. That's this white spot he talks about. This was the first time we had ever heard about this at trial. Put aside the question of how that happened, depositions. They never disclosed it. But put that aside. This is the first time we were hearing about it. And Judge Atlee made the decision that our expert neuroradiologist should be allowed to respond by reading just 7 pages of Keewack's testimony as if this had been disclosed before trial in the proper way, so he could answer it. Well, it was the right thing to do. Postal was a neuroradiologist, and he explained, in the first place, that white spot, a radiologist knows, that's not a blood clot. When they do the pictures, they've got to subtract out the skull, or you can't see anything. It's subtracting out the lighting for the skull, and it leaves a lighting artifact. That's all it was. It was not a blood clot. And besides, Dr. Keewack had put that in the wrong location for an A1 segment. It wasn't where the A1 would have been. Now, these were good things for the jury to know. They can believe whichever expert they want. But as if this opinion had been disclosed properly in the first place, Postal responds to it, an expert radiologist, and shows that it's error. And again, plaintiff says they objected. Page 4 of their reply, whenever I ask questions asking Postal to opine on Keewack, they never objected on the basis of asking them to opine on Keewack. You look up the references in their brief. Those are objections on hearsay, foundation, and learned treatise. Never am I asking him to comment on KEWAC. 3 claimed evidentiary errors. None was abuse of discretion. None was even a mistake. I ask you to affirm.
Very much.
I want to address a couple points real quickly, seriatim, if I can. There were no safety studies. The record established that. Dr. Vanderhaar admitted that. You can look to the record, Exhibit Bay 236. They never did any studies on the issue of safety. What they did was efficacy claims, so they could put ads out there that say, you know, this is faster, better, stronger than any other drug on the market. But, oh, by the way, we didn't have any strokes in our people who took this product during these efficacy studies. On the second issue, with respect to us somehow opening the door or bringing it up, I invite the court to review the case of Sheffield versus Superior, Supreme Court 800 Southern 2nd 197, which is when a motion in limine is denied, as was the case here, you can deflate the argument. You can bring it up in opening statement. You can handle it with evidence because you've already been advised by the court how the court is going to rule on the issue. And that's what we had to do. We had this bad Hobson's choice. Well, we know that she's letting it in. We know that it does not have scientific proof, and we've got to address that head on. Now, it's a confusing argument for us to hear, or for me to hear today, that, yes, we agree. Fredericks did not say it causes stroke, okay? Didn't cause Mr. SVOBODA's stroke. Well, then why was it admissible at all? And why was it improper for Dr. KEWAC to cross it off? But she did infer. She made the inference, and because it goes to this urban myth that when you have sex, you have strokes, that you have Valsalva. She assumed a fact which does not exist. It's a fact that had been imparted to Dr. Muldoon, the day before the trial about the Valsalva, this Valsalva maneuver, this fact that's so critical, this biologic certainty that occurs when there's no evidence on the record that it does occur.
Well, if it's a critical point, there's a statement by your opposing counsel that there was no objection made as far as the lack of predicate on that. Was there, was that particular matter discussed even in the motion in limine about this Valsalva movement?
She didn't disclose it in her deposition. You could look in her deposition transcript, and nowhere in the deposition, I asked her several different ways. The word Valsalva didn't come into my knowledge until we tried this case, and I heard it from Dr. Muldoon's lips, who apparently heard it from Mr. Scott's lips the day before. So this Valsalva was a complete surprise. And
if it didn't come up earlier in deposition so that it was part of your motion in limine, was it objected to on the record at trial that there was no predicate because there was no testimony that this Valsalva maneuver happens during sexual activity or anything like that? Did you make that objection to the trial court?
The basis that we argued was inadequate foundation, and I think that's entirely contained within it. It's part of the foundation. That what are the foundation, what are the predicate facts? The Valsalva, the scientific literature she's relying upon.
Even if it was an error, and I'm not saying that it was, but even if it was an error to allow that testimony, why wouldn't it be harmless error given that the jury had already heard the same thing from an authoritative text or treatise in cross-examination of your expert?
I invite your honors to the Lefebvre opinion, which is cited in my case. It is harmful error where the evidence is intended to play to the passions and prejudices of the jury. And this thing about sex and strokes is exactly that, playing to the passions and prejudice of the jury, giving them an alternative causation theory. That's where the harmful error occurs. It gives them something to hang their hat on because what happened? Sex is the most proximal in time to the stroke. Even though I'm not saying it caused it. Well, then why am I testifying about it? But, so he had sex an hour or 2 hours before his stroke. And so under Lefebvre, and I really invite you to the argument.
Your time. Thank you very much.
Thank you so much. I saw time clicking off. And the red light tells me to sit down. Thank you, Your Honors. It was a pleasure arguing before you, Your Honors.
Thank you all.